Welcome to Trial Lawyer Review, a podcast for and about trial lawyers. We will tell the stories about trial lawyers who go to battle every day in courtrooms throughout the United States for injury victims. This is about their stories and their practices. Hello everyone, I'm Jason Lazarus, your host for Trial Lawyer Review. Thank you for tuning in today for another episode. Trial Lawyer Review is brought to you by Synergy Settlement Services. In full disclosure, I'm not a professional podcaster. Instead, my day job is Chief Executive Officer of Synergy Settlement Services. Synergy allows trial lawyers to focus on what they do best by handling the difficult issues that arise at settlement, like troublesome lien resolution issues, Medicare secondary payer compliance, government benefit preservation techniques, and complex settlement planning.
Joining me today on Trial Lawyer Review is Teresa Kenyon. She's an incredibly talented subrogation attorney and admittedly the director of lien resolution for Synergy Settlement Services. I wanted her to be a guest on the podcast given her background and experience in an area very relevant to trial lawyers. I'm going to give you a little bit of a background. I'm going to read a little bit because she's got a pretty extensive background. Teresa spent almost a decade with the Rawlings Group, the largest health insurance subrogation company in the industry. She managed subrogation operations and served as in-house counsel for Rawlings Operating Center in Los Angeles. She represented the nation's top health insurance carriers, including Aetna, Blue Shield, and HealthNet. She has extensive knowledge of laws pertaining to healthcare subrogation, including the Employee Retirement Income Security Act, better known as ERISA, Federal Employees Health Benefits Act, better known as FEBA, the Medicare Secondary Payer Act, as well as state laws nationwide. Her team here at Synergy works to reduce these health insurance liens and more on behalf of injured claimants. Teresa graduated from the University of California, Irvine with a degree in psychology, like me. That was my same undergraduate degree, and she earned her JD from the University of Louisville Brandeis School of Law. Welcome to Trial Lawyer Review, Teresa. Thank you for joining me.
Thank you. Thank you for having me.
So before getting into the law stuff, I know that you relocated from California not too long ago and are now enjoying living on the beach here on the east coast of Florida. Still a culture shock going from Los Angeles to Florida?
Uh, yes and no. It's definitely different, but I like change. So it feels good to be in a different place. And I keep getting asked, "Do you miss California?" And my answer is not yet, but I'm sure I will eventually. And I'll make a trip. I'll make a visit.
We probably don't miss the income tax. State
Yeah,
income tax is not present here in Florida. It's a nice omission considering what that does for our paychecks here in Florida. So,
definitely a plus.
all right. So let's talk a little bit about how you got into the practice of law. What was the single biggest reason for you making the practice of law your career?
Well, it really comes down to I wanted to help people. Like you mentioned, I was a psychology degree, and that was really my intention right out of high school was I wanted to help people. And really, with that psychology degree, I got into various jobs where I was helping people, but they didn't want to be helped. So I worked in a psychiatric hospital with teenagers, so that had its level of difficulty. I worked for Child Protective Services, where I was helping the children, but the parents weren't too happy with me. So I was doing a lot of things where I was helping, but I didn't feel like I was helping. So really, it then turned to like, well, let's get into the law where I can actually help people. And my intention was to be a personal injury attorney.
It's funny because we're very similar in that regard because I was interested in psychology in terms of helping people. And when I was trying to decide what to do in between undergrad and going ultimately making the decision to go to law school, I worked at the Orange County Court Alternatives in the mental health unit. So in the Orlando, Maine 33rd Street jail on the psychiatric ward, which was a really interesting experience, but made me decide I really didn't want to deal with the psychiatric side of things and really made me interested more in pursuing the law. So interesting that we've got sort of that shared background. So I know Rawlings is based in Kentucky. Is that how you wound up getting into subrogation law since you went to school, law school in Kentucky? Because it's a rather
Yes.
specialized area of the law, and it seems like the people that wind up in that specialized area are coming out of Kentucky.
Right. Yeah, definitely. Kentucky is where perhaps where it started. I mean, that's certainly the lingo at the Rawlings Company is that it started there with Rawlings. But yes, so I graduated law school and I got a job with a personal injury firm that a couple of months later fell apart. So then I found myself jobless with a bar license, and Rawlings was advertising with some legal words in their listings, and so I ended up joining them. Had no idea what I was getting into, but I did know that I didn't want to work for an insurance company. um, and that's exactly what I ended up doing. So I had to talk myself into just that, that I'm still dealing with medicals, I'm dealing with injured people, I'm dealing with the law, but it wasn't quite what I had in mind, but I made it work.
Just the wrong side. We'll talk about that in a little bit. But
Yeah.
so, given your almost decade with Rawlings, I thought that you could offer trial lawyers some unique insights into the minds and operations of these recovery contractors like Rawlings. So, let's talk a little bit about that. How does a recovery contractor like Rawlings make money?
Yeah, well, they have contracts with health insurance carriers. So those are your Aetna, Kaiser, Highmark, Blue Cross. I mean, there's so many of them, right? And so those insurance carriers often have in-house subrogation units. Some still do, but they've been approached to outsource their subrogation work, and so companies like Rawlings and Optum and Conduent and various defense firms have popped up, and so it's a contract, and their pay is based on their results. So it's very much a contingency type of agreement. I believe like over time the amount of the contingency has decreased because there's become more competition in the market. So I've heard that originally it used to be a third. So whatever it is that a company like Rawlings collected, if they collected a $100,000 recovery check for the $200,000 in medical expenses that were paid, they got a third that of that 100,000 that they got to keep for themselves. I think that those numbers have decreased into the low teens, but it depends on the contract, depends on the client, depends on lots of things.
Are there any other things that you think are important for trial lawyers to understand about the business model of these recovery contractors?
Well, I mean, I think really having an understanding that there is that financial incentive for that vendor, that's just there, and really like there's still financial incentive for a lot of the employees as well. Depends on the company, but many of the handlers that are handling these liens that trial attorneys are talking to on a regular basis at Optum or Conduent, they might get a piece of that check as well for their bonus. Not all. Every company is run a little bit differently, but there is usually some kind of bonus that is attached to it by way of performance, and performance is judged by how little reduction you give. So that's what they're trying to do is reduce as little as possible, and then move on to the next file.
So talking about those file handlers, my understanding is that they don't just have a few files, they're loaded down with files. So they're quickly trying to resolve, but yet, achieve their bonus by, recovering the most dollars. Is that sort of the general idea out there?
Yeah, definitely. And even, in my role here, I've interviewed many people from other companies that have joined my team now, and they're all pretty similar, across the board with the company. So anywhere from 500 files to 1,000 files, or even 1,500 files, definite high volume. And then really to make their model work, you've got to get in and out of that file. So I know one frustrating thing that we experience here at Synergy, and certainly trial attorneys experience as well, is you sit down and put a very very thoughtful argument together, and what you get back is a form letter. And that's because they're clicking a couple buttons and they're sending you something off so that they can move on to that next file. So it's just a part of the beast, I guess.
So, roughly speaking, how large of a team does a company like Rawlings have behind it? Because I think one of the things that most lawyers don't realize is how big some of these entities are that they are fighting against and the kind of resources that they've got to fight.
Right. I do think that Rawlings is one of the biggest, and the last kind of number that I heard was that there were 400 subrogation analysts. Their location is like the size of a football field, um, on one floor, but there's three floors in that building, and then there's two other buildings. So it's definitely a very big campus. It's not just for subrogation; they do have other departments as well. Um, for Optum, I feel like it's maybe more like 60 to 80. Feels like less than 100. And then, we've got FIA and Conduent, and there's all those different companies that are involved. But it's not like there's just a couple people pushing paper. It's definite, large groups of people. I can tell you that Rawlings has huge training classes where they bring people in. There's 6 weeks of classroom training. After classroom training, you go to a special team where you have a dedicated team lead to answer all those questions every time you experience something for the first time. And you're in that protected environment for a couple of months before they release you to the football field, where you really start to ramp up your files and get to the 700-800 number after a couple months.
So I know you know this, that I was involved in an accident, and our health insurance plan, which was an ERISA plan but not self-funded, I had to fight with them because I decided I wanted to negotiate my own lien because I wanted to better understand the process, and I had a pretty good fight with our plan, which was United Health, and then so Optum, and ultimately it got to the point where they basically said, this is it. If you don't take this, we're referring it to outside counsel and you can litigate. Mine had first party benefits too, so there was some risk here in Florida because of that. But anyway, my question stems from that experience, which is, what is the typical likelihood of something being referred to outside counsel to actually litigate versus just bargaining, positioning, and is that a sign that, hey, you've gotten to the bottom when they're saying, hey, this is it. If you don't take this, we're gonna refer it out.
Yeah. Well, I mean, when it's being
That
said,
might be
it's
not be an easy question to answer
no.
succinctly, but
Yeah. Yeah. Well, and really, I mean, I've learned that so much in this business, the answer is it depends. It depends. There's so many factors that are involved. So yeah, each situation is a case by case kind of basis. But um, if it's being said, we're going to send it to outside counsel and we're going to litigate this. This is our final offer. There's a risk that they might do just that, but it also could just be a bark. I know that when I was representing on that side and had a team of file handlers that would bring me files and I would put together legal arguments in writing, I ended almost every single letter with just that sentiment. Doesn't mean that I even had everyone reviewed to go to that next level. But it was certainly a possibility, and it was my warning. It was my bark. And really, I feel like perhaps now, especially in the middle of COVID, with the slowdown of auto accidents, slowdown of surgeries that have prevented more medical malpractice cases and all of those kind of things, that these subrogation vendors are feeling that as well. And that we've even heard some of that their clients are getting more aggressive and wanting them to recover more in every opportunity, and that is something that they have in their back pocket. They do have outside counsel. They are able to send it that way, and there might be an uptick of it now because their books are feeling the heat.
yeah, I think that's good insight. So being at Rawlings for almost a decade, what was it like to be hired and trained by a group like Rawlings?
Yeah, well, as I mentioned, I mean, it was definitely like classroom training and I, lots of training materials. They have a really great training program. I mean, as much as here I am on this side and wouldn't want to admit that kind of thing. I mean, the fact is they do. So really, it's training their way, right? It's their interpretation of the law, and it's their scripting of what they think the file handler should say in response to an attorney saying X, and it's all, I mean, it's very well, it's a well-oiled machine for sure, but they have the answers, and they have the answers that they want those file handlers to put out. So I experienced it, a decade, more than a decade ago, and over time things just get better. So I have to imagine that they have continued to perfect that, especially since I've been gone. Other vendors, maybe not as much, some, but I do feel like there are a couple where I'm like, oh, it's one of those. They don't seem to have as much knowledge, or their interpretation really doesn't have any logic behind it. So it definitely depends. Not all subrogation vendors are the same. That's for sure.
But generally speaking, they're bigger outfits, they're well trained,
Oh yeah.
and you're not fighting an unsophisticated foe.
No, no. Even the defense firms that you see that are handling the subrogation, I mean, it's like that's what they are. They are a subrogation vendor defense firm, and that's all that they do. So, because it's such a specialized area of the law, if you're up against anybody that's their bread and butter, and that's all they do, you're in a tough spot, I think.
Are there any insights you can share about the processes that a group like Rawlings or other groups employ in terms of agreeing to reduce liens?
Well, that's one of those things that it definitely depends on a lot of factors. So I can tell you from where I came from that a file handler has limited ability to reduce. They would then have to get their supervisor to review, and that supervisor might have the ability to reduce a little bit more. Then there's the legal department that's above that might have the ability to reduce a little bit more. And then there's internal committees that you would present it to, and then sometimes the actual external client has to review. So whether that be the actual insurance carrier, or in the event of a self-funded plan, the actual employer group themselves. So there could be many different levels of review, and really that depends on the lien amount. It could depend on the settlement amount. It could depend on the state. It could depend on the lien type. It could depend on the insurance carrier, the employer. Like, I mean, there's so many different things that really, when you get a lien statement from whoever, you have no idea what those hoops are that file handler has to jump through. And really, I think that's the most frustrating part, is that for a trial attorney, you're having this communication with somebody who doesn't have any authority. And then you've got to trust them to go present all the right information to perhaps get you the reduction that you're looking for. And that's takes time. A lot of times there's delay. I mean, it's almost like the telephone game, right? Like by the time it gets to where it needs to get, I mean, who knows what's been presented.
Yeah, and I actually experienced that myself because, I finally got to, one of the higher up attorneys at Optum when I was negotiating mine, and it took, 3 or 4 months to get to that person that ultimately, I finally felt, okay, I think I've got the person with that authority. So I think that's interesting insight for attorneys to understand that specific inner working. So you've got a unique vantage point because you've been on this other side. So when you were on the other side, what were the top three biggest mistakes you saw from plaintiffs' lawyers in terms of the way they approach things when they were dealing with you?
Hmm. Top three mistakes. So it's a little
Or
bit of a
top
tricky
two?
one. Yeah.
How many others you can think of?
Yeah, we'll start with one, and we'll see how we go. Um, yeah, so I think, I mean, the biggest thing is not knowing which law applies, not having enough understanding on what this plan type is, because from me sitting in that seat, if I realized that whoever it was that I was talking to wasn't on the same level as me, then I knew I was going to win this battle. Um, and I hate saying that now. So, but it's true, right? Like it's you kind of size each other up in the very first interaction, you know. So you want to make sure that you're arguing the right law, that you understand that, like if it's a Medicare Advantage lien, that you're not arguing Allborn, which is going to apply to Medicaid, you know, and that kind of thing happens. And there might be pieces in the Allborn argument that you want to present, but if it's not something that actually matters, you certainly don't want to start with it, you know. So that's a big one. I would also say when it comes to those claim summaries, it can be tedious if there's many pages, but you've got to review those closely and make sure that everything that's on there should be on there. And if you have bills and you've got, you know, your own demand where you know what specials you've put together, that you're making sure that that is accurate, because that's your number, right? That's your starting place. So if that is incorrect and inaccurate, then you're starting any argument off on the wrong foot. So I definitely saw a lot of attorneys, it seemed, just put it in their file and then didn't want to discuss it until the case settled, and that's not a good thing. So I definitely say acknowledge that claim summary and make your arguments about that relatedness piece early on.
So, know the law, which is, interesting in terms of, from what I've heard anecdotally from those who've come from the other side, for example, where, you know, the other side may say, well, this is ERISA, and McCutcheon says we get full reimbursement. It's a self-funded ERISA plan, and that's not true. But I think there are some out there that don't really understand that there are techniques that can be brought to bear that will get the plan to ultimately reduce that lien. They're tough, they're harder, especially if the language is really good, because basically McCutcheon allows them to get around made whole and common fund if they expressly disavow it. But it's interesting that there is that. So that's really great. And then too, that disputing that unrelated care and making sure that that is pulled off early on are two great pieces of advice for the plaintiff's bar. All right, so now let's talk a little bit about what ultimately made you decide to make the switch from representing health insurance plans to now putting on the white hat and representing injury victims, and doing the good fight, or putting up the good fight for injury victims.
Yeah. Well, I mean, it was definitely an opportunity, right? And I took advantage of an opportunity, but it was definitely something that I wanted, you know. They talk a lot in the subrogation world about the golden handcuffs, and I'm sure that it exists in lots of different places. But I actually remember, like, right out of law school, I was working a temp job in Kentucky with Yum Brands, which is like KFC and Taco Bell and all that. And there was a paralegal in the legal department that I was working with who had worked for Equian. And she knew that I was getting ready to interview for Rawlings. And she said, "Oh no, golden handcuffs." So it was the first time I ever heard it. And at the time, it didn't register for me. But I definitely understand it in hindsight. So especially even with the people that I've brought over and had join me here on the Synergy team, same kind of thing. I mean, it really is like their pay structure allows people to stay and build those emotional walls where you ignore that there is a real life injured person on the other side. And instead, you're almost blinded by your own greed. And it's not a good feeling, you know. But if you build a big enough wall, then you continue to do it. So I had definitely started to seek other opportunities because it just, I mean, lots of factors, right? There's lots of reasons why you choose to leave a job. But I knew that if I was going to leave this job, that I was going to go work in a job that was more fulfilling and more aligned with what I wanted to do. So certainly have appreciated the Synergy opportunity, and just recently celebrated my 2-year anniversary here. So, but really, yeah, it was just about being aligned so that you could end your day and feel good about what you're doing, you know? And you can only kind of take that for so long where you're not doing that. So it's more about personal fulfillment, feeling good about yourself.
Yeah, it's one of the beauties of what we have. here at Synergy that every day we get to have the opportunity and privilege about improving lives. And you've heard me talk about that. And we had our all hands meeting today and talked about a particular lien resolution case that really embodied that idea of improving lives. I'm curious about the ideology and culture that you came from, because I know exactly what you described. When I was a defense attorney out of law school, I did insurance defense work. I somehow had to rationalize in my mind, that this person wasn't really that injured, or yeah, and that sort of, okay, you've got to convince yourself of that to be comfortable with what you're doing. I'm curious about like the ideology and culture of a Rawlings in that regard, because it doesn't seem like there's any heart there, right? It's just, okay, we got a job to do, and these people, they're just taking money out of our client's pocket ultimately.
Right. Yeah. I mean, and it really is like it's a company culture with these subrogation vendors to not care about that kind of stuff. So I'm sure trial attorneys who try to bring up those equitable factors and really try to like break down those walls of here's what this person has suffered, they've had that door shut pretty quickly because that is just what happens. So yeah, it's really it first thing that like somebody wants to hear about on that side is what did it settle for? And just like that, if they know that they're looking at a $20,000 lien and it settled for 100,000, there's enough money here. And they don't care about any of the other factors. And it's built in that way. It's an indoctrination in that setting. And then along with that, in order to continue this machine rowing without any heart, as you say, you've got to like create restrictions so that people are focused on other things, right? It's almost like a distraction. I've heard from other people from other companies that it's that there's a lot of I mean, definitely like that micromanagement kind of thing, like making sure that you're checking all the boxes, and it puts you on this avenue of being robotic. And again goes back to what I said, where you put a lot of thought as the attorney into a written argument on why this particular lien should be reduced, and what you get back is a form letter like from a robot. It didn't even really require somebody on the other side. So that really is. I don't think that any of them would admit it, but ultimately that's like the machine that has been built, and it's, I think, quite intentional.
So, what's been your greatest surprise or learning moment since you've made this switch over to the injury victim side of the equation?
Surprise. Um,
Or learning,
yeah,
whatever you think is relevant.
yeah. Well, I mean, one thing that was definitely surprising to me when was in my first couple of weeks on this side was just how different all of these subrogation vendors operate. So it's like I was 10 years in and indoctrinated, and this is how this is, and then when you see this, this is the answer. And I, of course, especially like with a legal mind, was looking at other things, and I'm like, that's not the only thing, but that door was shut, on me. Like, nope, don't go over there. Let's stay over here. So I think as much as I thought that I knew exactly what the other side would say, there's been plenty of times where we've had a communication with a different vendor and their position is not at all what that other vendor's is. So it's kind of amazing. This is like the law, right? This is the gray space of the law, and how, especially in this arena where there's not a lot of case law or guidance. There might be a statute, there might be one case, but it covers this one narrow point. What about everything else? So it really is just like all of these different people with their own interpretations. And then there's these business models that have been created around that interpretation, and then the buy-in that happens for the entire company, and then it goes rolling. And now you've got all these subrogation vendors that are doing that. So just the learn was just how vast the interpretation can be as it relates to this subject, where I really did feel like I've got the answer right here and I know the counter argument to that one, but then all of a sudden you realize there's five more. And that's the challenge, and that's interesting, but it was a little bit of a surprise and a learn for me.
So last question. Admittedly, it's a bit self-serving for Synergy because we are an outsourcing partner for law firms when it comes to lien resolution. But are there two or three things that you would recommend to trial lawyers in terms of setting up cases for the best possible lien resolution outcome when they outsource?
Well, I do think a big issue that becomes a bigger issue at the end if it's not addressed on the front end is this whole idea of pre-existing conditions. So this it definitely puts the trial attorney in like sitting on the fence, right? So when you're arguing to settle your underlying case, you're arguing that absolutely everything is related. Your demand, your complaint, like it includes everything. Well, you've got to know that that lien holder is going to ask for a copy of that document when you're asking for them to remove claims. And they're going to act like because it's in there, it's related. And we all know that that doesn't mean defense accepted it. It doesn't mean that you got paid for it. So if there is some, if you know that pre-existing is, or if causation or any of those things is going to be a problem, keep that in mind as you draft it. And I mean, it is like definitely like a fence sitting kind of thing. I don't know exactly how you would do it, but I just challenge trial attorneys to kind of have that in the back of their mind when like you are using this demand to get the biggest settlement possible. But if you know there's going to be a big lien, know that they're going to ask for it as well. So that's one big one that often becomes a problem, even from the synergy seat, where it's like, man, that demand is going to hurt us. And if only that attorney had thought about this part of it on the front end, we would be in a better place. So that's one.
Well, I think that we've given a pretty good, amount of information insight to our trial lawyer listeners. If somebody's got a question after they've listened to this podcast, what's the best way to get in touch with you?
Yeah, email is definitely best. So my email address is T for my first name and then my last name, KENYON at synergysettlements with an S.com.
So we'll put that in the show notes for listeners so that they can reach out to Teresa if they've got questions about lien resolution. And I want to thank Teresa for joining me today on Trial Lawyer Review, and we'll see
Yeah.
everybody on the next podcast. Thanks for tuning in to Trial Lawyer Review. You can find more at triallawyerreview.com and look for more episodes and more content coming in the future.